Welcome to our Arizona Revised Statutes video library. I'm Shawnna Riggers, Managing Attorney at Arizona Family Law Attorneys. My goal is to take this somewhat dry information, make it a little bit more entertaining, and also provide you with information regarding the laws that are applicable to dissolution, parenting time, custody, child support cases here in Arizona. This is being filmed in 2023, so it's important that if you're seeing that afterwards, that you double check the statute to make sure that it is the most current version. And if you have any questions regarding any of the material, as always, please feel free to reach out to us here at Arizona Family Law Attorneys, where we provide peace of mind as there is no substitute. I'm going to read the second half of 25-318 and discuss it at the end. If you have questions, reach out to me directly. Paragraph J. On the request of either party and except for good cause shown, the court shall require the parties to submit a debt distribution plan that states the following. 1. How community creditors will be paid. 2. Whether any agreements have been entered into between the parties as to responsibility for the payment of community debts, including what, if any, collateral will secure the payment of the debt. 3. Whether the parties have entered into agreements with creditors through which a community debt will be the sole responsibility of one party. K. The following form may be used to verify agreements with creditors. See the text of the statute in the link. Paragraph L. If the parties are not able to agree to a joint debt distribution plan pursuant to subsection J of this section, the court may order each party to submit a proposed debt distribution plan to the court. In its orders relating to the division of property, the court shall reflect the debt distribution plan approved by the court and shall confirm that any community debts that are made the sole responsibility of one of the parties by agreement with the creditor are the sole responsibilities of that party. M. An agreement with a creditor pursuant to subsection K of this agreement and section that assigns or otherwise modifies repayment responsibility for community debts secured by real property located in this state shall include the following. 1. A legal description of the real property. 2. A copy of the note and recorded security instrument, the repayment of which is to be assigned or modified by the agreement with the creditor. 3. A written and notarized acknowledgement that is executed by all parties to the debt, including the lender, and that states one of the following. A. The terms for the repayment of the debt remain unchanged. B. The terms for the repayment of the debt have been modified, and beginning on the date of the execution of the acknowledgement, the creditor has agreed that one of the debtors assumes the sole responsibility for the debt, and the other debtor is released from any further liability on the debt. C. The debt is paid in full, and the parties to the debt are released from any further liability. N. An agreement executed pursuant to subsection M of this section shall be recorded by either party in the county in which the real property is located. O. After an agreement is recorded pursuant to subsection N of this section, either party may request that on payment of the title company's fees for the document, a title company authorized to do business in the state provide the requesting party with a lien search report or other documentary evidence of liens and other agreements of record in the title to the property. P. If a property fails to comply with an order to pay debts, the court may enter orders transferring property of that spouse to compensate the other party. If the court finds that a party is in contempt as to an order to pay community debts, the court may impose appropriate sanctions under the law. A party must bring an action to enforce an order to pay a debt pursuant to this subsection within 2 years after the date in which the debt should have been paid in full. Within 30 days after receipt of a written request for information from a spouse who is a party to a dissolution of marriage or legal separation action, which includes the court and case number of the action, a creditor shall provide the balance and account status of any debts of either or both spouses identified by account number for which the requesting spouse may be liable to the creditor. R, if any part of the court's division of joint, common, or community property is in the nature of child support or spousal maintenance, the court shall make specific findings of fact and supporting conclusions of law in its decree. So 25.318 is a really long but very, very important statute. It talks about enforcement in this second half. And you can find out if your spouse has paid by obtaining information from the creditor. It also gives options so that you can restructure a debt with a creditor and ask that they make one or the other person responsible if it were previously a community debt. I would say I haven't personally seen people negotiate much of this. It is more so that like a house is refinanced completely. It's unlikely that a lender is willing to do this, but it is possible under the law so long as both parties and the lender agree. I would also say more commonly, someone will roll over a balance on a community credit card onto a completely separate credit card, and that way your ties with the other party are completely severed. So my professional opinion is that anything that you can do to make it so that you are not jointly tied to someone after the dissolution is done, that is what you want to do. If you need to refinance a debt solely in your name, if you need to sell a piece of property in order to avoid having a common debt between the two of you moving forward, that would be definitely my recommendation in this situation.